Good afternoon. This is a meeting of the Hampden Board of Selectmen being held in the townhouse, in our offices in the townhouse on August 7th, 2024. This meeting is being conducted in person and remotely using video conferencing technology. Please stand for the pledge of allegiance.
To the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
The main purpose of this, thank you very much. Is anyone recording the meeting other than us? Seeing no one. The main purpose of this meeting is to decide on whether we'll appeal the decision by the land court in the Garvey versus Hampden self-storage case. The last time we had a number of questions. I reached out to our attorney, he's responded to those questions. One of the questions I had was about what would be the potential for the appeals court to award damages to the plaintiff if we should lose the appeal. And he said the standard for an award of double fees and costs is generally whether there was no reasonable basis for accepting a reversal under current well-settled law. It is high standard which courts are generally reluctant to apply, especially against the municipality. That being said, there's a legitimate risk and there is a near guarantee that any appeal process will involve extra cost of fighting about that issue, which would drive up legal costs in my end, even if we prevail. I think it's a 50-50 question of whether an appeals court would grant this relief here. It's essentially left to the appeals court with broad discretion to decide either way. I asked a question of that, said prior to the meeting, I asked if he could get any clarification prior to the meeting for appeals court. He said no. We have two choices at this point: file an appeal of the judgment or seek clarification from the court regarding how they want the planning board to proceed. We cannot get the clarification before our decision must be made to appeal, which, by the way, the deadline is tomorrow. I asked, does the court's order remanding the case to the board for lawfully noticed public hearing mean a hearing with the published newspaper notice or just a public meeting notice under open meeting law? He said, the attorney responded, I would say that the land court left this phrasing vague intentionally. That being said, I would suggest in this case that a public hearing with full notice is safer, just to avoid any possible basis for appeal of the procedural aspects of the unsatisfied party. I asked us, after considering whether imposition of reasonable conditions is warranted, including the 21 conditions in the decision, mean that the board could possibly add additional conditions. The attorney responded, yes, provided they are reasonable and are not restrictive, that they are essentially act as a denial of the special permit. On that point, I would comment just personally, given the financial situation recently of self-storage units closing up and being abandoned, I would think the planning board might want to entertain a bond for decommissioning, but that's their decision. I asked if the newly constituted board could add additional conditions and how could that be done when two of the members had not participated in the original hearing. The attorney responded, that requires clarification from the land court. State law requires that votes for special permit and conditions must have 4 affirmative votes by planning board members who attended all hearings, other than 1 allowed absence. I asked, would the newly constituted board have a vote on each condition? And he said, I'm a little confused by newly constituted, but by that I mean we had a new person elected, we had another person appointed and that, so. But he said the planning board, in whatever form the land court tells us to take, would have to vote on every condition and receive 4 affirmative votes. I asked if the board adds additional conditions and the plaintiff objects to those additional conditions, what is the avenue after that? He responded, the applicant could appeal the special permit decision after the remand hearing. The planning board must grant the special permit, but there could be a fight over whether the conditions are reasonable. Abutters or other opponents could also try to appeal the decision, although it would be an uphill battle when the land court has already ordered that a special permit must be granted. I would say in that particular situation, it'd be a very odd situation for us, because if the abutters appealed the latest decision of the planning board, then the town would be in the position of having to defend the board against the abutters. So we'd be on the opposite side of what we were just on the opposite side of. Someone questioned whether one of the newly elected members, who was an active opponent of the special permit and testified against the project at the hearing, must recuse himself, and he responded, whether a new member is even eligible to vote on any of this is unanswered questions that we need clarification from the land court to address. If new members could vote, then the issue of the possible conflict is for the member in question to address personally. Which raised personally for myself the question of whether the former chairperson, who was recently reappointed, could vote because of his ex parte communications with the plaintiffs and his attacks on the board and myself personally. He said recusal questions are left to the individual board members. So,
Don, could I make one clarification? You read the first thing about the 50-50 question of whether an appeals will grant
Right.
relief. I think that was strictly in terms of the damages, right?
damages.
Right, I
the
want to be clear,
damages.
people didn't think it's
Yeah,
50-50
no,
for the
not
appeal.
50-50, no,
Right.
he is pretty confident that we would not prevail in the appeal.
Because there's no defect,
There's
it's
no
not,
there's
it's not
no
about the
defect
case,
in
it's about the
judge's thing, right.
process. Right.
The 50-50 refers to whether they award damages or not. And he said they're usually reluctant to award damages against the municipality. However, if they feel it's frivolous or unreasonable, and, you know, you're doing this to delay that, the court might find that. So, that's where we are. We have to make a decision, so we'll need a motion of some type. Or further, if we can have some further discussion.
I think we pay a pretty competent attorney for their opinion. I think we've also gotten the opinion from our town administrator, who has a law degree as well, that he would be reluctant to file this appeal based on what we have in front of us. Again, that there is no perceived defect in the process that was taken. The appeal does not speak to the merits of the claim. It just speaks to the process the judge took. And I think it would be the potential that it would be viewed as frivolous, as you said, might be a bit of a danger to us as well, opening the door to potential damages. I think we have the opportunity to use the planning board's process to impose reasonable additional conditions as well, and put it in their hands to protect the town from that standpoint. So I would be not in favor of proceeding with an appeal to this decision.
We have a motion, so we can just deal with it under a motion.
All right, unless that was kind of a statement, but do you want to make a statement first and then we move, or which? All right, I'll make a motion. I'll make a motion that we do not exercise an appeal to this decision.
Second for discussion.
Okay. We have a motion and a second, made and seconded, okay, good.
I'm just gonna say based on, based on town council's opinion, I don't feel comfortable with the appeal process.
With one, missed the last
I
part.
don't feel comfortable with the appeal process.
Okay. This is one of those occasions, rare occasions, where your personal feelings have to be subservient to your stewardship of the town's funds and the process. You know, I have some substantial issues with certain things. However, I think that as a steward for the town's funds and practical matter, and additionally being concerned about the other applicant now filing to reconsider, have the court reconsider that decision, I would reluctantly vote not to appeal.
If I can make a comment, Don, I think that reflects both on what you've done in the past. I go back to the school settlement, and you looked at the bigger picture at that point there and said what's the right thing to do at that point, and I applaud you for that.
I agree.
So vote. John Flynn?
Aye to the motion.
Aye. Okay, 3-0 not to appeal. Anything else to come before the board? Motion to adjourn?
Yeah, just quickly, so we are meeting next Monday. Lauren, you're out next week, right?
Yes.
Do we want to, I'm not sure what the agenda looks like at this point.
Yeah, I don't
Do we
know.
want to ask
Lunch
James?
right now.
I think James already said she'd do it, right?
She said she would, I don't know if she has
That's
to,
fine.
but.
Yeah, okay.
Motion to approve, motion to adjourn.
One question,
Yeah.
who guides the planning board on all these outstanding issues in that email?
I would say Jesse and
Jesse,
Brian.
I'm gonna send it, I wanna send, as soon as I get out of here, I'll send an email to Jesse saying we voted not to appeal, to go forward with seeking the clarification, what the planning board needs to do, and what, kinda like a timeline too, you need a
Right.
timeline. Because if you're gonna do a hearing, you gotta give 14 days,
Yeah,
twice.
I gotta post it within 14 days and outside of 14 days.
Yeah,
So should that communication basically be planning, Brian and Jesse?
yeah,
We
yeah,
can be CC'd on it.
I'll CC
We'll be
the.
No, we'll be CC'd on what they do,
Yeah, yeah,
because it's gonna be real, pretty much their charge going
Yeah, after
forward,
that.
yeah.
Right, once we get instructions on how
Yeah.
to proceed
yeah.
Right.
and what board members
We'll-
can proceed.
Proceed, right.
Motion to adjourn.
Thank you.
Second.
All in favor?
Aye.